I'm Gareth Brayans, and I'm the managing partner of BDBF, and I'm delighted that Emma Burrows is here alongside me, and she's one of our associates in the team. So now, at the core of this webinar is what happens when employees allow the personal to cross over into the workplace, or when employers express beliefs about things that go much wider than their actual business, or perhaps refrain from going to that extent. And that, of course, can cause offence and controversy with colleagues, or in the case of staff making comments, for example, on social media, that can harm an employer's brand when they do so. So suffice to say, it doesn't always end well for employers or employees. And the question is really twofold. How do employers navigate this? And what stance, if any, should employers take on hot button issues like Black Lives Matter, Brexit, Gaza, Trump, trans issues, and so on? So in that context, you may have thought that it was risky of me to post about this webinar on my Facebook page. And as you can see from the comments section, my wife certainly did think it was dangerous for me to be doing this webinar. So for the voyeuristic amongst you, hoping to watch a lawyer blow up what had been until now, I think, a relatively successful 30-year career, I'm going to disappoint you, because what I'm not actually going to do today, and nor is Emma, is share our views on any of these hot button issues. But what we are going to do, of course, is talk about how they impact the workplace. And I've also double checked that my privacy settings on Facebook are on, so you won't be able to look at this unless you're already my Facebook friend. Okay, turning to the next slide, what are we going to cover today? The answer is Emma is going to start by talking about how the law protects certain religions and beliefs in the workplace. I'm then going to talk about what beliefs and expressions of belief are protected by the law and what are out of scope. Emma's then going to cover what corporate statements of belief, so where do corporate statements of belief and DEI stand within UK law now? And then I will talk about what rights and obligations employers have to respond to individual employees' expressions of belief that cause offence to others. And finally, Emma's going to try and conclude with what is really the safe zone for employers. The aim is that we speak for about 50 minutes, and after that, there will be some time for questions. We are presenting in webinar format today, which means that the best way to ask any questions is to type them into the Q&A box, which you'll find at the bottom of the screen. And you can ask questions anonymously if you prefer. Today's session will be recorded, although the Q&As will not be. After the session, we will circulate the recording together with a copy of the slides that we're using today. So, without further ado, how does the law protect people with certain beliefs? I'm going to hand over to Emma for that.
Thanks, Gareth. So I'm going to go through in a very high level the legal protections that are offered under the Equality Act and otherwise. So I'm sure most of you will know that there are 9 protected characteristics under the Equality Act, but this webinar is going to focus on religion and belief. Now, the way these characteristics are protected is through a series of different claims that can arise. So on the next slide, the potential claims that can arise under the Equality Act are set out. So firstly, discrimination, direct discrimination. This arises where someone is treated less favourably because of a protected characteristic. So in this case, their religion or belief. So for example, an employee who is fired because they are Muslim. Now, manifestation of that belief is also protected under this, and Gareth is going to talk more about the manifestation of beliefs later in the webinar, but that manifestation is where that belief is expressed outwardly through actions or words. So for example, posts on social media like Gareth's Facebook post. Now, there is no defence to direct discrimination for an employer, except in cases of manifestation of belief where an employer can objectively justify that discriminatory treatment. So that would be if the manifestation of the belief resulted in, for example, reputational damage to the business. Moving on to indirect discrimination. So this is where a provision, criterion, or practice is applied by the employer. That applies to everybody, but disadvantages people with a particular religion or belief. So a very basic example of that would be a factory requiring everyone to work on Sundays, which would disadvantage Christians who would attend church on Sundays. Now, indirect discrimination can be objectively justified. So in that same example, it may be a defence if the factory's biggest customer requires its orders to be sent out on a Sunday and there was no way around that. So now turning to harassment. So most of you will probably think about that in the context of sexual harassment, but harassment can be committed in relation to any of those 9 characteristics that you saw earlier. So yes, including religion or belief. This is a slightly more wordy definition of the claim. So on the next slide, I've set out the definition here. So it's unwanted conduct related to the religion or belief, which has the purpose or effect of violating the complainant's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. So for example, someone making jokes in the office that relate to someone's religion. So on the next slide, there are a few key points to note, which regard circumstances that can be unwanted even in these situations. So just picking out a few, it can happen even if someone has previously tolerated the behaviour. So just because someone is putting up with it doesn't mean that it was wanted. And also it can be conduct of this nature when it is not directed towards the person who is complaining and that there was no intention that they would ever see or hear it. Now, this is subject to the so-called snowflake test. So if the harassment was not intentional, it's only unlawful if it was reasonable for the conduct to have that effect on the complainant. And that would take account of the perceptions of the recipient of the behaviour and also all of the other circumstances of the case. So just going back to the slide summarising the Equality Act claims. So if someone complains about harassment or becomes involved in another worker's discrimination complaint, so for example, giving supporting evidence, they will have done what is known as a protected act. Now, if someone is subjected to retaliatory treatment because they have done a protected act, or it is thought that they have or may do, that can lead to a separate legal claim known as victimization. And that detrimental treatment can be conducted by the employer or a co-worker of the employee who's done that protected act, and it has quite a wide meaning. So it can cover things like unjustified disciplinary action, but also not promoting someone. Now, just finally on this slide, the defences in relation to harassment and victimisation. So an employer can avoid liability through the reasonable steps defence. And that is where an employer can show that they took all reasonable steps to prevent the employee from committing that act. So victimising someone or harassing someone or doing anything of that general description. So the final type of claim I'm going to discuss, which is on the next slide, is unfair dismissal claims. So Gareth is going to talk about when beliefs are protected under the Equality Act. But this unfair dismissal claim is available to employees dismissed for their beliefs or in relation to their beliefs, regardless of whether those beliefs attract protection under the Equality Act. So in all circumstances, you will need to ensure that you can identify a fair reason for the dismissal, that you follow a fair process in every case, and the employer decision should be reasonable in all of the circumstances. Now, it's important to note that there is a 2-year service requirement, or is there, in unfair dismissal cases. So ordinarily, employees do need that 2-year service to have protection from unfair dismissal. But where that dismissal is for the sole or principal reason of the employee's political opinions or affiliations, that 2-year service requirement is dispensed with. Now, that doesn't lead to an automatic unfair dismissal claim, which some of you might be familiar with, because the tribunal would still look at the reasonableness of the employer's actions overall, but that's something to be aware of. And then it's also worth noting that the Employment Rights Bill plans to do away with the 2-year service requirement for unfair dismissal. So we don't fully know what that looks like yet, and there may be a statutory probationary period with a lighter touch dismissal process during that time, but that's one to watch as well. As I mentioned, Gareth's now going to talk about when beliefs are protected by the law.
I beg your pardon. I'm going to start again. Sorry, I was on mute. So I was saying we know how religion and belief is protected, but are all forms protected? And whilst we probably know what a religion is, what amounts to a belief? So the starting point is, of course, the Equality Act and the language of the Equality Act. And unsurprisingly, it says religion is covered, and religion includes a reference to a lack of religion. And of course, that can mean both atheism, but also not having the relevant religion in the particular context. So, for example, I once dealt with an employee who was himself Jewish. That wasn't actually relevant. The relevant point was that he was not Catholic in an environment where almost all of his colleagues were Catholic, and he believed that that was counting against him. So it wasn't his religion to the extent he had one. It was not having the relevant religion in that context. So that's all covered. And we know that belief means any religious or philosophical belief, and a reference to belief again includes a reference to lack of belief. So far so good, but what amounts to a belief? So the leading case in this regard is a case called Granger and Nicholson. The case involved sort of quite extreme levels of commitment to environmentalism. And he was, amongst other things, an ethical vegan and so on. Essentially what was established was that the high-level test as to whether you have a belief within the meaning of the Equality Act is that the belief must be genuinely held. The belief must not just be an opinion or viewpoint on a current state of affairs. For example, you may or may not think that Kemi Badenoch is doing a good job as leader of the Conservative Party. Now, in one sense, that's a belief, but that is not a belief within the meaning of the Equality Act, because that's just thoughts about the current state of affairs. It must relate to weighty and substantial aspects of human life and behaviour. It must have a minimum level of cogency, seriousness, cohesion, and importance. And finally, it must be worthy of respect in a democratic society and not incompatible with human dignity and not in conflict with the fundamental rights of others. Now, of course, these are very high-level principles that could be applied to a whole range of human experience and approaches to life. And there are many nuances to them. So, for example, someone might be, as part of their belief system, might be a vegan, an ethical vegan who does not believe that animals should be exploited for human use at all. Forgive me, my phone should not be exploited for human use at all. By contrast, you might be a vegan just because you're on a health kick. And just being on a health kick certainly doesn't make it a belief within the meaning of the Equality Act. But if it forms part of a wider system of belief, then it can be different. So how have employment tribunals applied these high-level principles in practice? Well, the answer is there are a very wide range of outcomes. It looks like there's a transition on slide. Yeah. So with the caveat that I've just given you about all the nuances within different types of belief, here is a list of beliefs that claimants in the employment tribunal have asserted which have been held not to have been protected. Now, I said I'm not going to read them all out, but you will imagine why many of these will have been excluded on one of the 5 Granger tests that I pointed out. But for example, the membership of a political party, such as the Scottish National Party or the Labour Party, or indeed the Conservative Party, that of itself, it may be a manifestation of a belief, but it's not a belief of itself, because you do not have to have any particular beliefs to join a political party. Some of these, for example, fear of catching COVID, wearing face masks, and so forth, they really relate to ephemeral matters. They're not about long-standing, it's just a viewpoint really on a current state of affairs. Some of these things are just not related to weighty matters of human life and existence. So, for example, support for a football club. And finally, of course, some of them just are not worthy of respect in a democratic society, such as Holocaust denial. On the other hand, turning to the next slide, there are many beliefs which tribunals have found capable of protection. And you can see in amongst this list of important examples are many of the buzzwords and culturally divisive issues of the times. Indeed, Brexit, trans issues, Zionism, anti-Zionism, and so forth are all present. So with the trans issues were encapsulated in a case brought by a lady called Maya Forstater, who held what are described there as gender critical beliefs. And you can see that second along in the middle row. And that is a belief that gender is determined by biology, not by self-identification, indeed probably aligning with how the Supreme Court has just interpreted the Equality Act. And she succeeded in 2021 in establishing the Employment Appeal Tribunal that she had a belief capable of protection under the Equality Act. Now, whilst in the final box there, we have put anti-Zionism in there, I think given the high level of interest in that particular subject at the moment and what's going on in the world, I just want to delve a little bit more into the nuances of that particular case. So if we go to the next slide, the case involved David Miller, who was a professor of sociology at Bristol University, and he defined Zionism as the belief that a state for Jewish people ought to be established and maintained in the territory formerly comprising the British Mandate of Palestine. In other words, he defined someone as a Zionist as someone who either supported the creation of Israel as a state or continues to support Israel as a state to continue to exist. And he was fervently opposed to Zionism. Now, if we go to the next slide, now from the Granger test, it's probably right to say that there was no issues that these beliefs of his were genuinely held, and there was no issue that they related to a weighty and substantial aspect of human behavior and existence. And it was also accepted by both parties that his beliefs had a minimum level of cohesion and seriousness. So one of the questions, though, was, sorry, next slide, please. Sorry, beg your pardon, go back. Sorry, one slide. Thank you, I apologize. Yeah, was anti-Zionism a belief or was it an opinion? So the University of Bristol said it wasn't a belief, it was just an opinion based on his sociological research. He said that was not true, it was a lifelong belief. He was not open to having his mind changed, and his belief and his research was not done to explore what the right outcome was, but to back up his beliefs. And the tribunal accepted that, and on that basis, it was held that his opinions amounted to a belief. One argument that had been put against him was in Granger and Nicholson, the case about the committed environmentalist. He'd given evidence to say that his views about environmentalism touched every aspect of his life, including the clothes he wore, the food he ate, where he went on holiday, and so forth. The university said, well, these kind of beliefs were not equivalent. It couldn't be said that Mr. Miller's anti-Zionism touched every aspect of his life, but the tribunal concluded that it didn't need to. So turning then to the next question was, is anti-Zionism worthy of respect in a democratic society? So assuming it is a belief, which they found it was, or was it incompatible with human dignity and the fundamental rights of others? Now, had the tribunal found that anti-Zionism is just a species of anti-Semitism, in other words, racism against Jews, then I think very likely Miller would have failed at that hurdle. However, for its own reasons, the University of Bristol did not run that argument, and therefore the point was conceded. But that, of course, doesn't mean it would be conceded again. So if the point is going to be relitigated in a different context, then that point, I suspect, will be brought to the fore. They also took account of the fact that Professor Miller said he was not open to violence as a means of opposing Zionism. On that basis, relying on the following statement in Forstater, they concluded that his beliefs were protected by the Act. So in Forstater, it was said that only beliefs that would be an affront to convention principles in a manner akin to that of pursuing totalitarianism or advocating Nazism or espousing violence and hatred in the gravest of forms should not be capable of being worthy of respect in a democratic society. Beliefs that are offensive, shocking, or even disturbing to others, and which fall into the less grave forms of hate speech, would not be excluded from the protection. However, the manifestation of such beliefs may, depending on circumstances, be justifiably restricted. Now, these are all references to the convention, being the European Convention of Human Rights, which I'll return to. But suffice to say, the point I want to leave you with before handing over to Emma and then returning to this subject is that a very strong distinction exists in law between suffering discrimination for having a controversial belief, where employees basically have an unqualified right to protection, and suffering discrimination for expressing or manifesting controversial beliefs, where the rights of others figure much more highly in the balance, and it's a much more nuanced test. But before we go on to look at the freedoms and limitations of individual expression of belief in the workplace, I want to let Emma come back in and take a look at where we now stand in terms of corporate expressions of belief.
Yeah, so I think it's fair to say that most of the webinar so far has considered the expression of belief by individuals, but I'm going to turn that on its head briefly and consider the implications of corporations expressing beliefs, and particularly in the context of the growing DEI backlash. So on the next slide, I just want to spend a couple of minutes on the terminology here. So there is no statutory definition of DEI. It's not included in the Equality Act. So there's no single definition to work from, and different organisations may have slightly different understandings of the term. On the slide, we've set out our understandings of DEI. So diversity, equity and inclusion are defined there down the left. I'm not going to go through each of those in detail. So the term DEI denotes that set of objectives, whereas a DEI programme is an umbrella referring to initiatives, policies and practices aimed at achieving those objectives. And those initiatives, etc., are on the right in the small boxes. So you'll see some of these examples capture many standard measures taken by employers, which you're probably familiar with. So having anti-discrimination policies and training, offering enhanced pay for family leave, and making adjustments for disabled workers. But DEI might also capture more interventionist measures, including things like having blind CVs, so where gender and name, etc., are removed to try and avoid unconscious bias, and also preferential treatment in recruitment and promotion. So making race or gender, for example, a factor considered in hiring or promotion decisions. And that's something that happens in the US, but generally wouldn't be permitted in the UK, but more on that later. So on the next slide, this shows a summary timeline of how things have been unfolding. And I think you could be forgiven for thinking that it is something fairly recent, but the DEI backlash has been brewing for some time. Most recently, following Trump's second win, there has been some voluntary dismantling of DEI initiatives in the private sector. So, for example, Walmart announced that it would stop using the term DEI altogether, and also to drop DEI training. Amazon also said it was winding down what they called outdated programs and materials related to representation and inclusion. And then more recently in January, President Trump signed 2 executive orders targeting DEI initiatives. So firstly, directing federal agencies to dismantle DEI programs, and secondly, prohibiting private organizations from implementing those DEI measures for positions funded by federal contracts. And there is also an obligation on federal employees to report colleagues still furthering those efforts. So although those executive orders don't apply to private sector employers, Trump has asked the Attorney General's office to look into ways that it can regulate the private sector. So it does seem that the government might be moving in that direction, and certainly that has already rippled into the private sector. So on the next slide, there is a table of all of the measures that have been taken recently by private sector employees. And you can see that most commonly things like diversity hiring targets or supplier objectives are the ones that have been acted on. With some of these, it is a bit harder to know whether they are substantive changes or whether there's a degree of rebranding that's kind of designed to escape the attention of the Attorney General's office. So is it just the DEI department being disbanded and going by another name, and just effectively still existing? So that's what's happening across the pond, but let's look close to home at the UK. So on this slide, we've highlighted some of the limited responses from UK employers to the DEI rollback so far, and I'm just going to pick out a couple of these. So BT have removed their DEI targets from annual bonus calculations for middle managers. Previously, 10% of those bonuses were calculated based on DEI metrics. However, that hasn't actually changed for the top 550 senior leaders at BT. And then the FCA and PRA, so that's the Financial Conduct Authority and Prudential Regulation Authority. Back in 2023, they consulted on improving diversity and inclusion in the firms that they regulate. And there were some new rules planned to mandate reporting on staff diversity, including age, ethnicity, gender, religion, and sexual orientation. But it was announced last month that there are no plans to take those rules forward. So on the next slide, it's clear that there is the potential for UK companies to follow suit and follow what's happening in America with the DEI backlash, particularly if UK companies have strong US operations. But UK employers are operating in a different political, cultural, and legal ecosystem. So politically, our current government were elected on a mandate to expand discrimination protection. So, for example, the Employment Rights Bill is taking forward measures on sexual harassment, third-party harassment, and also mandatory equality action plans. And separately, a new equality, race, and disability bill will introduce ethnicity and disability pay gap reporting, amongst other things. Obviously, that's not without opposition. And for example, Reform campaigned on a manifesto committed to ending DEI programs at the last election. But I think culturally, the concept of DEI is quite well established in the UK, and it's arguably broadly accepted. So in a survey by YouGov in 2023, 66% of all working Britons said that the workplace DEI was important to them when they were considering job opportunities. So if employers are looking to roll back DEI in the UK, they could potentially be out of step with peers who continue to embrace DEI, particularly if they're trying to recruit people who it is important to. And then on the legal side, the UK's legal approach to DEI is actually somewhat weaker than in the US. So there is, in fact, less to roll back. And what I mean by that is that the Equality Act doesn't permit affirmative action or positive discrimination to achieve equality of outcomes. So, for example, age is a protected characteristic that protects people of all ages. Race is a protected characteristic and all races are protected equally, etc. The only slight exception to that is in respect of disabled workers, where employers are required to take reasonable steps to remove that disadvantage. So the way the UK Equality Act covers this is in relation to positive action measures, and those are aimed to redress disadvantage in order to achieve equality of opportunity. But they apply in only very narrow circumstances. So, for example, positive action at the point of recruitment, for example, to favour a candidate from a protected group over candidates not from that group. But those measures are entirely voluntary, and they can be very tricky to get right because they are so narrow. And that's particularly in the context of recruitment. So I wouldn't be surprised if you hadn't even kind of realised that that was out there. And I think it's safe to say that they are not really widely applied. Obviously, any steps to roll back DEI initiatives would need to be in line with UK employment law, and DEI training, rolling that back, I think raises the risk of harassment claims. You'll recall earlier I said that there was a reasonable steps defence to prevent harassment, and training would be one of those reasonable steps. So if you're doing away with that, you're opening yourself up to those potential claims. And there's also a separate duty to prevent sexual harassment, which came in October last year, so potentially wouldn't be complying with that duty either. So on the next slide, what effects might we see in the UK in the future? So rebranding potentially of DEI. I sort of mentioned that earlier in respect of what's happening in the US, but we might see a greater emphasis on inclusion than on diversity and equity. And some commentators have suggested that DEI might sort of merge with ESG so that the focus is more on ethics generally. We might also see employers disaffiliating with social causes and events, so focusing on what's happening in the workplace with less endorsement and focus on wider social causes and events that might attract scrutiny or criticism. So, for example, Pride, Black Lives Matter, and International Women's Day. And finally, the rollback in the US could lead people to express more so-called anti-woke views. So as Gareth discussed earlier, the key point is that if the belief is protected in law, you're going to need to tread carefully to avoid an act of belief discrimination. So that does open up an array of dilemmas for employers, which Gareth is going to address next.
Okay, so why do employers sometimes effectively interfere in people's rights to express their beliefs? So the next slide, please. Really, there are potentially 4 reasons why employers tend to object to employees voicing controversial beliefs. The first is that sometimes those beliefs run contrary to the organization's values. For example, Wetherspoons recently fired a self-described anti-woke barman who voiced his objections to the annual Gay Pride Parade. And the employer, Wetherspoons, said they felt his objections ran contradictory to the kind of atmospheres they try and create in their bars, which are namely one of inclusivity. Probably the most common reason why employers feel the need to intervene when people are expressing controversial views, typically on social media, but maybe just in kind of more workplace banter, is because they're concerned about the impact on others, and particularly colleagues, and potentially a wider group of people like customers. So, for example, in Forstater, where she was expressing her views around gender fluidity pretty kind of vociferously, I think it was around protecting, for example, trans employees. And in the case of Miller, it was probably around protecting particularly Jewish students at the university. Reputational damage is obviously a genuine concern for many employers who will be worried about being associated with controversial views being expressed by their employees. And a good example of that was a case called Gibbons, where the employee was employed by the British Council, and he had posted some negative remarks about actually a minor member, by which I mean a child member of the royal family. And obviously the aim of the British Council is, amongst other things, to promote the UK as a constitutional monarchy. So therefore his expressing those views really ran contrary to the whole purpose of the British Council, and it was held to be lawful to intervene. And sometimes expressions of beliefs actually just amount to a regulatory breach or even a criminal offence. And for example, the Solicitors Regulation Authority has some very strict rules about what we solicitors can say. And a solicitor was recently struck off for making anti-Semitic remarks. And indeed, some of those remarks may amount to criminal harassment or defamation and so forth. So, of course, employers do have a right to intervene, but as sure as when an employer intervenes, the employee is going to say, but what about my human rights? And what about my right to freedom of thought, conscience, and religion, and to manifest thought, conscience, and belief? And what about my right to free speech, freedom of expression, meaning to hold opinions and to receive and impart information and ideas? But the answer to that question, really, as I left you hanging before we went on to Emma's section, is that the convention says you have a right to complete non-interference with protected beliefs. But when it comes to manifestation of those beliefs, the question is whether it is proportionate, is the interference with the manifestation, proportionate to protect public safety or public order or the rights and freedoms of others. And there is much more of a balancing exercise to be conducted. Next slide, please. So there is a distinction, as I keep saying, it's absolutely critical to understand it, between belief, which has absolute protection, and manifestation of belief, which has qualified protection. Now, the leading case of this is the recent decision of the Court of Appeal on Higgs and Farmer School. And I think the facts are important, so I'm going to go through them in quite a lot of detail. So Christy Higgs was employed latterly as a pastoral administrator and work experience manager for this secondary school in Gloucestershire. She'd grown up in the area, which is relevant for reasons I'll come to, and she was a committed Christian. She had a private Facebook group with about 100 people on it. It was published in her maiden name, and she used her married name at work. And the Facebook page did not link her with the school, albeit that some of the people in that group of 100 people would have known she worked at the school. She had grown up in the area in which she was now employed by the school. So she posted one key post and she reposted another key post. And I want to just look at each of those in a little bit of detail. So this is the post she did herself. What she wrote herself is between the asterisks. The rest of it was a repost. So there she says, please read this. They are brainwashing our children. And then she reposted what was a petition. And you'll see in the petition, in the wording used to support the petition, it says children will be taught that all relationships are equally valid and normal, so that same-sex marriage is exactly the same as traditional marriage, and that gender is a matter of choice, not biology. Please sign this petition. They've already started to brainwash our innocent, wonderfully created children, and it's happening in our local primary school now. So she was expressing a combination of, or supporting the expression of a combination of traditional Christian belief around marriage, and also she was supporting gender critical beliefs around gender fluidity and trans issues. Next slide, please. She also have reposted this post from a US gender critical post. Again, largely around the same issues, around US version of PHSE lessons. While normal Americans are busy at work trying to provide for their families, liberal school systems are busy indoctrinating their children. They're busy recruiting children for the transgender roster. They're using our children to promote their gender-free society of madness. And goes on to say, I've put the full post there, but I'm going to, as you see, just quoting the yellow parts, lying to children and convincing them that they can be anything they want to be, when in reality they can't, is a form of child abuse, especially when it entails the changing of one's genitalia or ingesting hormones. She obviously meant to say LGBT crowd, with the assistance of the progressive school systems, are destroying the minds of normal children by promoting mental illness. Delusional thinking is a form of psychotic thinking, and we have professionals promoting it to our young kids. So that is what she posted and reposted. Go to the next slide, please. It transpires that one member of this group, who was, notionally a friend of Miss Higgs, felt moved to write to the head teacher of the school, and this is what she's written. She wrote anonymously, I've noticed that a member of your staff who works directly with children has been posting homophobic and prejudiced views against the LGBT community on Facebook. I'm concerned that this individual may exert influence over the vulnerable pupils that may end up in isolation for whatever reason. I find these views offensive, and I'm sure that when you look into it, you will understand my concern. I'd rather remain anonymous as the person in question is, and therefore you would have found out who this person was, so it was anonymized. I've attached a couple of screenshots so you can see what I'm referring to. So the school then conducts an investigation, next slide please, and it concludes that she has to be dismissed. And it says that the posts were discriminatory against the complainant. Now, once it came to be litigated, that actually argument was abandoned because it wasn't clear who the complainant was and whether she had a right not to suffer discrimination and whether indeed the test of harassment would have been met. But what was continued to be in contention in the legal proceedings was the reason for dismissal was that it was risk of reputational harm caused by the post. It was acknowledged that there had not actually been any reputational harm going beyond this one individual complaint, that the language used may demean LGBT pupils, although none, of course, were aware of the language and it wasn't directed at them, that her post called into question her suitability to work with children as a pastoral manager, though again, there had not actually been any complaints by parents or children about the interactions she had in a 6-year career at the school, that her online persona was not consistent with the professional image expected of someone working in the school. Now, those were the findings. They considered it to be, on its face, gross misconduct, but given her 6 years of service to the school, they considered alternatives to dismissal, but they felt none were available, primarily because she was asked whether she had any understanding of what the impact of her posts would be on other people, and she basically intimated that she had no insight. She had refused to remove the posts. When she was asked whether she regretted anything, the only thing she regretted was use of the word brainwashing, which she thought probably did go too far. So next slide, please. So the first question then, of course, would be, were these posts an expression of belief? And perhaps unsurprisingly, these were held to be an expression of belief. as the court says, if the claimant's actions have a sufficiently close and direct nexus to an underlying religion or belief, such that they are properly to be understood as a manifestation of that religion or belief, any limitation would need to be such as is prescribed by law and necessary in one of the ways identified in the European Convention of Human Rights. Now, what is that balancing act? We finally get to the wording itself. Freedom to manifest one's religion or beliefs shall be subject only to such limitations as are prescribed by law and are necessary in a democratic society in the interests of public safety, for the protection of public order, health or morals, or most relevantly in employment cases, for the protection of the rights and freedoms of others. So just reiterating that, you can intervene and in people's right of free expression if it's in the interests of the protection of the rights and freedoms of others, and it's a necessary intervention. So next slide, please. How did those principles apply in the David Miller case? Sorry, bear with me. Can you go to the slide after this? And one more again. No, okay, so can you go back? Sorry, go back to before I move on to David Miller, I just want to deal with a couple of issues, right? So you may be wondering, did Miss Higgs win or lose her case? And the answer is she won her case, and her dismissal was held to be an unlawful interference in her expression of religion and belief, and therefore she won her claim for discrimination, direct discrimination on the grounds of religion and belief. So why did she win? The answer is that it was a private Facebook in her maiden names, not in her work name. She was criticizing government policy. She wasn't actually criticizing the school. And in fact, she was talking about how government policy was manifesting itself in a primary school when she, of course, taught in a different secondary school. Whilst the language of the post would cause offence to many, it was held not to be extreme. And particular reference was paid to the fact that the more intemperate language was not hers, that was stuff she'd reposted. And the court drew a distinction between what someone posts and what someone reposts. In terms of her lack of insight, the court said that's to be expected in these kind of cases and should not be treated as fatal. But the key point was that the real essence of every aspect of the reason as to why she'd been dismissed was there was no evidence of reputational damage. The risk was merely speculative. And there was no evidence that she treated LGBTQ plus pupils worse in her role or expressed her views at work in any way over a long and unblemished career. And for that reason, it was held that it was an overreaction and an inappropriate intervention in her exercise of her rights. The court said that basically the same test applies in a direct discrimination about expression of belief as applies to an indirect discrimination claim in all other forms of discrimination. In other words, was the interference a proportionate means of achieving a legitimate aim? And in this case, it was held to have gone too far. So turning now finally to David Miller and how that played out in his case. So you recall that I was explaining to you that David Miller was a self-proclaimed anti-Zionist, and that the tribunal upheld that anti-Zionism was a belief worthy of protection in a democratic society, albeit it didn't examine whether or not it was a racist belief. He taught in lectures that Zionism was one of the 5 pillars of Islamophobia in British society. In a letter to a Jewish student, he said Zionism is a racist, violent, imperialist ideology premised on ethnic cleansing. It is an endemically anti-Arab and Islamophobic, and it has no place in any society. He also wrote in the student newspaper that members of the Jewish society in Bristol, that's a university Jewish society, were the pawns of Israel, which he described as a settler colonialist racist state. Now, he was sacked by the university, but he won his claim for discrimination. They said he should have received a final written warning rather than being sacked for his conduct. So he didn't get a clean win. So, but he did get something of a win. So how did this happen? Next slide, please. So the first question for the university to answer is it needed to have a legitimate aim to interfere with his beliefs at all. And the tribunal held that there was a legitimate aim, namely to protect those holding other beliefs, presumably Zionist beliefs, And they also needed to protect the university's reputation, although they didn't need to protect the university's reputation insofar as being a hotbed of racism or anti-Semitism, because the university had conceded that his views were not racist or anti-Semitic. So there was definitely a legitimate aim. Was the interference proportionate? Well, on the one hand, there was significant harm to the university's reputation, and there'd been an impact on donations. And the tribunal said itself that for Professor Miller, particularly in a position of power over students that a professor has over his students, for him to communicate in the way he did with students and to bring students and university societies, such as the Jewish Society, front and center of his attacks was extraordinary and ill-judged. But on the other hand, the tribunal also said that the comments made were related to legitimate areas of academic research, and they were concerned about the chilling effect of a decision to dismiss him, a university professor, for what he was saying in lectures, amongst other things, what the impact of that would be on freedom of speech within an academic institution. So taking all of that together, the tribunal took a middle path and said he should have been given a final written warning not to involve students in and student societies in his public comments. And accordingly, his claim that the disciplining him and putting him through a disciplinary process was an act of harassment failed, because that was a lawful and legitimate thing for him to have done, and for the university to have done. And indeed, the university was right to discipline him, but they said to fire him had gone too far, albeit his compensation was then reduced because of the chance that he would have been fired for crossing the line at a later date in any event. So that was how it panned out. What are the lessons from all of this? Next slide, please. So I think the key takeaways are that in Higgs, the language used may have been offensive, but it really has to be highly offensive to justify dismissal. That there is a distinction, a sensible distinction to be drawn between whether the employee is themselves the author of the words or whether they are simply reposting words, and depending whether they appear to be supporting what they are reposting. In terms of there being a risk of reputational damage, that of course must be real, not merely speculative. But in this case, as I said, there was no connection to the school. The posting was to a group of 100 people. It is legitimate to interrogate whether someone posting in this way will have an impact on their work. But in this case, she'd been at the school for 6 years and it had no impact on her work. And she was clear that she would not allow it to do so. Lack of insight, as I said before, is to be expected in beliefs cases, and that does not mean that just dismissal will necessarily be justified. And finally, the court agreed that the school was entitled to investigate the matter, but it was debatable whether it was necessary to suspend her, let alone conduct a disciplinary process. So where does all this leave employers about what they should do? And to that, I'm going to hand over back to Emma.
Yes, so you're probably now wondering in this complicated legal landscape that we've laid out for you, what you need to be doing. So you'll be pleased to hear that we do have some answers for you. So I think the first thing to say is that these cases are very fact specific and nuanced. And I think the most important takeaway is that they should be dealt with on a case-by-case basis. And you'd probably agree that it would be wise to take legal advice before doing anything. In terms of proactive steps that you can take, those are laid out on the slide. So you want to be proactively regulating staff behaviour. So the aim being to prevent the behaviour occurring in the first place, to protect you from potential claims, and also the wider impacts like reputational damage, etc., that have been discussed. So the starting point is a suite of well-drafted documents, which are invaluable when it comes to responding to problematic expressions of belief or opinion. So just going through each of these in turn, you want a code of conduct that sets out the expected standards of behaviour, and you make that clear that the circumstances in which that extends to time outside of work, so that's clearly defined. You'd also want your social media and IT policies potentially to prohibit staff from accessing social media for personal use during working time, or at any time on a work device, and making it clear that doing so could be treated as misconduct, and giving specific examples of expectations regarding social media in non-working time. So, for example, if the person is putting on their social media where they work, making it clear that that could have the capacity to impact the organisation. And obviously that's going to be more likely in respect of senior roles where their views could be taken by others as the views of the organisation. So another thing you could do is ask employees to make sure that they express that their views are their own and not the organisation's on those accounts. And you'd also want to be making clear that conduct on personal social media could result in disciplinary action up to dismissal, and with examples of what that behaviour might look like. Then equality and anti-harassment policies, so making it clear what characteristics are protected, giving examples of, in particular, protected beliefs, and explaining what types of behaviour could be harassment. And then your disciplinary rules need to underpin all of this and make it clear that breaches of the code of conduct and other internal policies could constitute misconduct or gross misconduct. And then you probably want to make sure that staff are providing a written acknowledgement that they've read and understood all those terms, and obviously keeping a record of that written acknowledgement on file. And then embedding those policies by providing training to staff about equality, harassment, and social media conduct, and also refreshing it. So what happens when someone has already expressed a problematic view? So the steps are laid out on the slide as to what you might want to do. So you need to consider which rights are engaged. Is the belief protected, either under the Equality Act or Article 9 engaged? That might not always be possible because you might not know what the underlying beliefs are or the strength of them. But from the Forstater case, the gender critical case that Gareth mentioned, we know that the vast majority of beliefs will be deemed worthy of respect in a democratic society. And it's also safest to assume that unfair dismissal rights apply. With suspension, you need to be careful about this. If you're thinking about suspending an employee, it shouldn't be an automatic reaction. You need to consider the ACAS guidance on suspension. Is there an alternative, for example? And if you do suspend, keep it short and under review. You need to be analysing exactly why that expressed view amounts to misconduct. So sometimes the view might not be closely connected to protected belief, and so might not be regarded as a manifestation of that belief at all. But it's generally safe to assume that the expressed belief is a manifestation of a protected belief, in which case you need to show that it was objectionable and that it jeopardized one or more of your legitimate interests. So each case is going to turn on its own facts, and a full and fair investigation will be needed. I don't think I need to say that these cases are usually very complex, and you'll need to assess and weigh up the factors from Higgs, which Gareth went through in brief. Given the time, I'm not going to go through each of those factors in detail, but I have prepared a separate handout that does summarise them all, which will be sent out with the recording. So then if you get to the point, having considered all of that disciplinary action is needed, the disciplinary process needs to be fair, and you need to be following the ACAS code of conduct on that. And then you need to be looking at the evidence on both sides, obviously, and making sure that that approach is consistent across similar cases that you may encounter. As Gareth mentioned earlier, there may be a grievance lodged alongside this where the employee subject to disciplinary action alleges discrimination, potentially in relation to the belief that they've expressed, and that would count as a protected act. So you need to be careful then to avoid subsequent detrimental treatment, including by co-workers of the employee, because that could lead to a victimization claim. And then finally, onto the sanction, it should always be the least intrusive way possible to achieve the objective in question. You need to be balancing the rights of the employee against the employer's interests, and considering whether the dismissal is really necessary. Could a lesser sanction be appropriate, such as a warning or asking the employee to take down the post? But it is worth noting that even a lesser disciplinary sanction could be viewed as an act of discrimination. and potentially used as the basis for a constructive dismissal. So just handing back to Gareth. You're on mute, Gareth.
That is basically it. Thank you very much for listening. I hope we have left you with a better understanding what the law says you can do when people are voicing difficult beliefs at work that are causing disruption or potentially reputational damage to you.